Good evening, everyone. Due to the fact that we got some recent legal advice, we're going to take 5 minutes to review, so we might not start till 5 or 10 past 7. Microphones are going on.
Okay.
Hello, everybody. My name's Suzanne Ryan. I'm standing in for the chairman. I'm going to call a meeting to order of 10/2/23 at, looks like 5 past 7. And I'll introduce Sarah Silk to my right as the clerk, Luke Friedenberg, voting member, myself, Suzanne Ryan, voting member, and the three of us are voting members. Alternates are Sabette Strawman, Kate Mahone. Chair Audrey Klein has recused herself and stepped down. And as in the last meeting of the 25th, I will again appoint Sabette, Strawman, and Kate McMahon. Oh, okay, I think it's spelled different. Chuck Sumner is excused. So this is a continued hearing of 925 on the Brown appeal of administrative decision. And we are here to hear an administrative appeal of a building permit for the construction conversion of a space above the garage into a duplex. Building permit of 72623, number 203000468, lot 217013 in the C1 Central Business District under zoning authority 17589, and in the interpretation and in the interpretation of dimensional controls, and 175, 128 erosion controls impact has been brought up. The board took jurisdiction at the last hearing under 676.51 and 674.33, and it has under 674.33.1, the ZBA has the authority to reverse or affirm and hear and decide appeals that are alleged there is an error of administrative official. What I'm going to do at this point is I'm going to open the continued hearing for the Brown application of 925. And Mr. Brown, you're welcome to come up and give us any new information you have on your appeal that you filed on August 23rd. So do you have some new information? Okay, please.
Good evening. Thanks again. Okay. This past week has been quite busy. I've had several conversations with Mr. Walker, Mr. Beckwith's attorney, reviewing proposed plans for drainage improvements. I've been asked several times in this past week to drop this appeal and accept this drainage plan as the way to move forward. I have respectfully declined to drop the idea of dropping this appeal. So this week, to bring people up to speed, I met with Mr. Walker. We talked about various things around the topics of building in the town and this specific piece of property. A comment was made that all these regulations are going to make it too expensive for young families to build homes. Well, I said, no, it doesn't. Any experienced builder should know, at least relatively speaking, if a project is even somewhat feasible for the prospective homeowner before starting. Don't get it near done and find out there's things we didn't think about, which is the current situation here. More specifically, making this a problem that others have to deal with later, which again is why we're here. Mr. Walker also presented me a drawing. I have that drawing. I'm sure he's going to give you copies of it, so I'm not going to bother you with that at this time, of a proposed drainage plan for the property you just walked through. I saw it. I am happy that he showed it to me. Again, he asked me in person if I would accept this and drop this appeal. And within about 3 minutes of looking at this plan, I was asked to sign off that it was acceptable to me. My statement was simple. It's not my position in this to accept your drainage plan for a property that's not mine. That's not what I'm here for. I then asked, where's the engineering stamp on this great drawing? I was told there wasn't time for that. Really? I was also told, well, there wasn't time to do the calculations for this drainage plan that we've spent the time drawing. So again, furthering my response, so on paper this looks good, but who's doing the work to prove and put their head in this, that this is going to work? I continue to say the flaw I see in this plan already, and I'm not here to say I'm the DPW expert. First and foremost, I'm not. But as an engineer, I can say, I'm looking at a plan with a problem. You get all this water captured now on this property. That sounds great. Send it to the storm drain like you're suggesting. My question is, if the storm drain cannot handle the capacity, what then? I was told, then it's a town problem. This is why I'm here tonight, because things get kicked to be somebody else's problem. I will point out that this problem that says send the water to the storm drain system, for those that did the walk tonight, we're the last house at the bottom of the hill, we're the last storm drain at the bottom of the hill. If that overflows, guess where it's coming? So I want somebody beyond Mr. Austin to say, it's okay, that's a good plan. It needs to be done by somebody that knows what they're doing with drain water, retention, and dispersion. And in this case, the town has to also be involved in that because it's their system this is being dumped into. So, continuing on, again, this is really the problem I'm at. Now, some examples of some things that have happened this year that I need to remind everybody, apparently. This winter, Mr. Beckwith had problems with water in his basement. He thought it was okay to pump that water live onto the street all winter long. For anybody that lives or is driving that street knows that there's been solid ice coming out of the front of that house all winter, which is a hazard. And I think you don't have to look too far to say that's probably not something that we should allow. Visits, site visits of 7/11 and 9/11. Now, I'm asking the board this because to me this doesn't smell right, it doesn't look right. If you had a dozen or more people show up at your front door for a meeting that you supposedly weren't notified of, and the plaintiff was standing in that group, and this was your chance to, again, regardless of notice, they're going to go and have a meeting about my property. I should probably get up there and give them all the reasons that they should continue it next week instead of not going. Now, to me, I ask the question to the board, is that because he really didn't want to go? Or is it better to say he didn't go, and this is, again, just my opinion, and not show you what's really going on that property?
Mr. Brown,
Yes.
we're well aware of what happened on that issue, and that was the first meeting. We have had a site visit tonight, so
Okay. Well,
that's not relevant
I'm leading into the
this
closing.
time.
okay. Well, I'm leading into the closing right now. Okay. Neighborly behavior. Total disregard for the neighbors. Now, I'm going to give this as good a visual description as I can. The Beckwith world is this, and the world seems to need to revolve around it, or evolve around it. Total disregard for the neighbors in the community of Libby Street and what his actions have caused for damage to abutting properties. Parking wherever he feels suitable, in front of people's houses, places where some neighbors have had to put up no parking signs to clear out their area. Pumping water directly into Libby Street. Planning meetings where he makes public statements that this backyard's not changing at all. The Zillow retraction, right out of nowhere.
Mr. Brown, again.
Well, the reason I'm pointing this out is
we have to stick to what your
okay, I understand, but what I want to get to, I'll give you the latest fact then. I hired a survey company, and today I got the results regarding the right-of-way that I know has been publicly stated at the planning meetings. I know it's been stated here that it's Mr. Beckwith's right-of-way. I'm here to make a correction to that. It is not Mr. Beckwith's right-of-way. It is the right-of-way of 30 Libby Street, 24 Libby Street, 20 Libby Street, and 16. All of ours. It is a public right-of-way for all of those lots, not Mr. Beckwith's.
You have that in writing?
Yes, I do.
Can you present it to the board?
I can present it here, and I will send you the email copy. I received it just before heading out from Massachusetts to come up here.
Thank you.
And the research was done by a surveying company that's local. Okay? So lastly, I know you're probably not going to like this, but I'm going to say it anyway. There was a comment made on the site visit tonight by Mr. Beckwith that seemed to question my integrity. I'll here to speak to that directly. I'm not the one saying what is fact and is not. Any questions this board has or homeowners have to ask, please ask them. I'll give you the best of my ability to an honest answer. And I think some of the people in this room that I haven't seen since high school can attest to what has happened on that property from when they were kids and that know me. I don't get pleasure out of driving at the end of my workday up here from Massachusetts to go to these meetings. I really would rather not.
Okay.
But I want this to stop. Respectfully, Derek Brown. Yes.
I have a question.
Luke.
Mr. Brown, I have just a couple quick questions. And just indulge me in some of these, because I don't know the answers to them. That's why I'm asking them. One's an open-ended question, which probably shouldn't ask, but I really do want your opinion on it. What do you think should happen here tonight?
What I think should happen is there should be drainage addressed before that project can move forward. Honestly, I think it should be rolled back to a garage with storage because that's what it was supposed to be, though the planning department clearly knew otherwise was the objective here. That was stated in person to me by the building inspector when I went to review the file. That they all knew exactly what the, quote, end game was, but yet it was permitted to keep moving. Okay? So personally, it was deceptive.
Have you been counseled by Audrey Klein on this application?
Actually, she wasn't. I actually approached her, asking her specifically, I don't know you, why are you here? And that's when I found out she represented Mr. Kent. Because this has been not a new topic. I've been around. I'm just more visible now because now I own the property so I can speak with a little more leverage in this room versus watch my mother try to fight this alone.
All set?
I'm all set, thank you.
I'm going to go around this way. Oh, okay.
Thank you, Ray.
Use your microphone.
Yep. You gave me four numbers, well, the board four numbers, and I just want to confirm who lives at which of these numbers because we have a drawing here and the numbers don't match.
Sure.
So if the right-of-way is for 16, that's Mr. Beckwith's lot, correct?
Correct.
Who is number 20?
Mr. Hart, Mr. and Mrs. Hart,
And 24 would then
Mr.
be
and Mrs.
Fernald?
Fernald. Correct.
And 30 is, I know you...
30 is me.
Right, okay.
My
thank
wife
you.
and I. Now, specifically,
Yep.
that property that has our house was originally owned by the Grange Hall. There was no house there. So there's no easement onto our property. It starts at the high line of our property and goes up to the church parking lot. And it is on the abutter's side, 14 feet wide. It's not on the church side of that line. It's on the abutter's side of that line.
I'm not sure I understand.
Okay, so what that means is
Give me
if
some
you...
orientation, please.
Yeah, sure, absolutely. Thank you. Good question. So if you're standing in the church parking lot looking down the hill, right? You remember the mini excavator you saw there?
Yes.
It was on the inside of the line, but there was a stake in the ground there. Somebody had asked about where the property line was. That line, pretty much where the mowed tall stuff starts, right? To the right of it is the abutter's property. The tall grass side is the church property. So that right-of-way is on the property line of all the abutters, extending 14 feet into the abutters as a private easement, excuse me, a public easement.
Okay. So it is not on the church property going down the back. It's actually to the right of that if you're looking down the hill on the abutter's property?
Correct,
Thank
correct.
you. I'm all set.
Okay. Oh, I'm sorry, Sabette.
I just want to clarify a statement that you made when you were talking about Mr. Walker asking you to drop the case. You said they had made a proposal about a plan for drainage, and you said, I just want someone other than Mr. Austin to look at this plan. Were you speaking hypothetically, or were you saying that Tavis Austin had actually reviewed the drainage plan that was presented to you?
As I understand it, and again, as I understand it, he had been given a copy of this plan, and he said it looked good. Now, that's just what I was told. Now, maybe I misheard that, okay? But to the first part of your question, this is above my pay grade, and honestly, I think it's above the planning board's pay grade. There should be an engineering firm look at this and say, okay, what are we going to do with this water, and can the system handle it? Because when I asked where was this water going to go, I was told it'll go to Lake Winnipesaukee. Well, no, it won't. It'll go down to the back bay, down the storm drain
No, I
system.
can definitely understand wanting to have an engineer look at it, but thank you. I just wanted to clarify that statement.
All set?
All set? Yep.
Okay.
You may get a chance later. You set, all set? Yep. Yeah.
Thank you.
I would like to mention that we had a site plan this evening, and a site visit, I'm sorry, thank you. And Sarah took some notes on that. It will be part of the record. In the interim between the last meeting and this meeting, Mr. Brown sent to Mr. Austin some pictures taken from computer of that Xylo thing, and also Zillow. You can tell I don't use it, and some pictures of I guess that was all that drainage issue. So for the record, they'll be in a file. And Luke, did you get a chance to discuss any of this, the towns?
I confirm that the town, as Mr. Brown submitted, did do work to alleviate or attempt to alleviate some of the drainage problems on his property during the time that he stated. There was not anything else in the file other than what Mr. Brown, that wasn't even in the file, so thank you for providing that. So now it's in the file. There was knowledge of that. It wasn't Mr. Ford just doing it. The town had knowledge of it, and the town has done work like that in the past to alleviate drainage issues on private property, tying in, I believe, Mr. Brown's, part of Mr. Brown's perimeter drain to the stormwater.
Thank you. And Mr. Austin, I have some questions for you, please. Will you please go to the podium? This is out of my, I don't do that. This is out of my domain. This is the building permit, I guess it's a application. You've got this memorized by heart, I'm sure, but.
No, I don't. I don't issue
The,
those.
Could you let the mic have us?
No, I don't.
it's,
I don't
Can you
have it
tell us
memorized.
which-
It's just
all
not
right,
something
but
I issue.
you're well aware of how this works.
Yeah?
Susie,
Yeah.
so we can follow along, can you tell us which building permit you're using, what date?
This is a building permit for the duplex on 726.
Thank you.
And it's signed off by Jason, I believe, a J is Jason. And there's 1, 2, 3, 4, and then a bunch of required inspections. So when there's an X on there, does that mean it applies, it doesn't apply, it's non-applicable? What of all those?
In that instance, X means applicable.
It means what?
Applicable.
Applicable. And does it mean that, well, it says required inspection, erosion, sediment control, footing piers, foundation, under slab, electric service, plumbing. So the code officer looked at all these things already?
As related to the duplex, yes.
And and since he signed off, he felt that we're in compliance?
I don't know that. Just because the permit was issued doesn't mean the inspection was completed.
Well, what does it mean when he signed?
That means he met the criteria to have a permit issued, and it was issued with those criteria.
And does he have an occupancy permit?
For storage. Garage with storage.
So I would assume then he felt that these things were met to get an occupancy permit.
Not if that's a permit for a duplex.
Oh, he doesn't, okay. All right. Well, I don't know if that answered my question, but thank you for your help.
Sure.
The answer is always in the question, and I'm sure I didn't ask the right question.
Can I, Suzanne, Madam Chair, can I ask Tavis a question? You can sit down. I think it's an important question to ask him, if that's okay. I don't think he's been asked this question, and I'd like to hear his answer. Tavis, why do you feel that the duplex meets 175?
175-55, it's a non-conforming lot. It's a legal existing non-conforming lot. 175-55 very clearly states that in the case of a grandfathered lot or a legal existing non-conforming lot, that frontage and lot area do not have to comply.
And
I could read it specifically if you want.
no, you do not. That is why you issued, that is what you went off of to issue the duplex permit.
Yes, that is what is relied upon for every lot that does not comply with the current standards.
May I follow that up? So, Tavis, that was something we talked about with our attorney a good bit, and I think, help me, Suzanne, if I get this incorrect, but this relates, because it's unclear, because those that ordinance can be interpreted some different ways, apparently, she said that we need to have evidence of administrative gloss that undersized lots in the area have been built on in the past. And now this is something that I think Mr. Walker argued, that there were a number of undersized lots that have been built on the past. We don't have any specific information about that. That was just kind of generally brought up.
Could you, that's a very good point. Could you hold that as a question for Attorney Walker?
Well, but my question to Tavis would be, because you've just stated very clearly that that was the basis for your decision in issuing the building permit. So do you have evidence of administrative gloss here where there has been a history of this happening in the past?
I would estimate that 90% of the building permits issued in this town rely upon that clause. There are very few lots, particularly those created prior to 1987, that comply with today's regulations. In the days of yore, there were not things along the lines of 10-acre zoning, 5-acre zoning, 3-acre zoning, et cetera. So to that end, every lot that was created prior to zoning would be subject to that clause, which is the majority of downtown Wolfeboro.
But meaning that they've been built on without variances? Because I think one of the things
Yes.
we talked about is that would have normally been a variance.
Built on without variances, based on no variances for lot size. There might be variances, as we heard last meeting with the Hart location.
Okay.
They weren't criticized for lot size, but they had to get a variance for setback.
So are you insinuating that this administrative gloss is recent or just something that happened since, the 1940s or whatever?
Well, no, because there
There's
wasn't zoning in 1940.
Okay, whenever zoning started, because most of the downtown has had something built upon it long before 1987,
Correct.
before zoning was around.
So if you want to put a
So
part...
that wouldn't be administrative gloss, because it would have been no gloss, because there would have been no zoning.
Sure there is. Was Downtown Grill there in 1987? Were the apartments above Avery Building there in 1987? with the expansion of all the residential units in downtown there in 1987? I mean, I don't have the specifics because I wasn't asked by the board prior to this evening.
I want you all to save these questions again for Mr. Walker, Attorney Walker.
Yeah.
And I will tell you that, where'd I write it? Shoot, I just had it. Zoning was adopted in 1939, Part 1. I'm going to open this up to the public now. Nope. I'm going to go to Mr. Brown next.
No, he was already up.
Huh?
You're going to Mr. Beckwith. Mr. Brown was already up.
Sorry. Mr. Beckworth, Attorney Walker, and then we'll open it up to the public.
Thank you. So, a couple of comments. A whole bunch of things have been said in the last 20 minutes, and I have things that I specifically want to say, but let me just go sideways and address some of them. So there was a comment about ice being in the street. And one of the reasons is the house up above Mr. Beckwith, the pipes froze in that house. And water was spewing out, flooded his basement, and presumptively went downhill, and it was a real problem. But that's what caused the icing. He had to pump his basement out because the house above him had its pipes broke and flooded. So that's why the water uncharacteristically ended up in the street because of that problem. There's been some discussion about a right-of-way. Totally irrelevant. It's not part of the appeal, never brought up. But I'll produce a deed, nonetheless, even though it's irrelevant, that says we have a right-of-way to come through. There's no dispute about the fact that they can access their property on a right-of-way. As to your comments, Sabette, about building on other lots, and Tavis's response was that 90% of the lots, fall under this category. And I've indicated, my belief is that it's grandfathered, and I cited 2 cases last time, but I will reiterate that the ordinance, in my opinion, couldn't be clearer. 175-55 says that a non-conforming lot does not have to comply with area or frontage. That's the whole basis of the appeal. I don't know why we're even here. 175-55 says you're exempt from frontage and area requirements. Exempt. Don't have to comply at all. That's the sole basis of the appeal under 175-89 is your lot's too small. It's not too small. It's exempt, and I believe that I gave this board that last time, and if I didn't, you can take a look at it. Well, I'll pull it out in a sec.
Are you referring to the Babcock versus Rye handout that you gave us?
Say again, could you speak in the...
I'm sorry. Are you referring to the Babcock versus Rye citation that you passed out to us, or are you referring to the ordinance? When you said you were looking for something you passed out to us last
Yeah,
time.
so I was looking for the ordinance itself, which I have, and I'll give you a second, but it's 175-55. I did bring some extra copies of that, and I'd be happy to pass it out if you don't have the ordinance handy.
Excuse me. 175-55.
Yes.
It seems as that was the case of what you present, that the planning department should have picked up on that when the application came in, and under the planner's review, notified us of this statute. We're getting, not statute, but ordinance, and we're getting that now. And I have to wonder why. If you knew this at the last meeting, why you didn't say so?
I didn't find it until this weekend myself. I knew the cases were there. I knew the law was in support of that, but I couldn't find it. And if you hadn't given me this week, I probably wouldn't have. But I stumbled across it on Saturday. Otherwise, I would have been delighted to bring it up, so we wouldn't have to come back tonight. But I have it right here, and I'll hand it out.
Well, let me continue on this, if I might. That
Thank you.
Well, let's see what you've got. Might be interesting. Thanks.
Again, this is what
All
Tavis
right.
indicated
No,
that he...
let me go on this. That 175.55 was amended in 2011. In 175.75, terms define density and size was amended in 2017. This Part 1 is superseded by the new requirements. This is not applicable
No.
to this situation. Well, you may say no. We'll find out someday whether it is or isn't. But 175 was amended in 2017.
What are you saying,
Pat-
what are you saying was amended? What section of the ordinance?
175, 175, 55 was, 175.55 was amended in 2011.
So can we just stop on that just for 1 sec? So that's what you have in front of you, and that very clearly says that this application, this property, is exempt from the area requirements. That's the sole basis of his appeal, 175.
I'm arguing that it's not exempt.
Well,
I'm saying that it was amended in, well, let me find it, 175. The problem here is, we've got this Part 1 and Part 2. Part 2 is zoning. Part 1 is town ordinances, don't spit on the sidewalk. Part 2 is zoning. And there's a
so
confusion.
can I just disagree with that?
Well,
And I struggled myself with what does Part 1 mean? So if you go to the zoning ordinance, 175, the very first page, page 1.
wait a minute, I've got a copy of it. I handed it out to everybody just now.
It's purpose right here.
No,
175.1 is what he's talking about.
what I gave you, have you got that?
Well, I'm happy to hand mine around if that would make it easier or faster.
That one. And is there another
So
one?
the very, very first page of the zoning ordinance, table of contents.
This,
Nope.
this. Well, maybe you live in a different town than I do, but this is what I got out of the. This is what's online on the website. Well, that's the problem. You got to go to the hard copy.
But it says Part 1, right there at the top.
What does that say?
Skip that for a minute.
No, why? That says Part 1.
Look at that. I don't know what that is, but I'll get to it in a second. I'll just make my point. Part 1's here. You don't get to Part 2. Yeah, sorry. Thank you for that. So Part 1 starts at Section 1, 175.1. Part 2 doesn't start until Section 192, all the way at the end of the ordinance.
Part 2, Chapter 175 is zoning, 175.1 through 175.215. And 175 was amended, what did I just say? 2017. What you're using is superseded by this.
What
No,
are you-
we can argue it. I can't argue it.
So
I'm not
wh-
an attorney.
Where are you saying where are you saying that was amended? What I have in front of me says that 175.55 was amended in 2011. That was a decade ago. So what are you referring to, Suzanne? What are you, why are you suggesting that does not apply?
Because you're saying that 175.55 makes the application
Makes this-
null and void.
I agree. It makes this
And I'm
property
saying,
exempt.
no, it doesn't, that has been superseded with a town meeting vote in 2000, what do I keep saying, 17.
So what
And
section?
what's happened is administratively is a mess up. You got one thing on the website, you got one thing in a hard copy, you got one thing that you've got, I've got one thing I've got. So I don't think we can settle that tonight. I think that this board is going to go forward with this application,
So
with due
can I
respect.
just see whatever you're referring to?
You can, yeah, right here.
Don't forget, people, that's my copy. Just,
I can't find my copy, and the other thing is, I got so much paper here. Where's the other thing that goes with that? Isn't there something, let me see.
no.
Do you have the letter that
You can't
I'm
give
gonna
this
give
to
it
him.
to him. I'm not gonna, I want to check it again. Okay, then I gotta go to, what are we looking at, 175, 175? It doesn't exist anymore. It's superseded by 175, 175.
That's the definition of terms, 175, 175.
Yeah,
175, 175 are just terms,
It is,
just definitions.
it is. And on the building,
Get closer to the mic.
Use your mic.
sorry, on the building permit, it doesn't, duplex doesn't meet the definition of duplex, the building permit application.
That wasn't appealed.
Pardon me?
That wasn't appealed.
Yeah, I agree.
Not on this application, no.
so the confusion here is that Part 1 is adopted in 1939. Along the way came Part 2, and they separated out types of ordinances. And you got the one like spit on the sidewalk or where you dock your boat and stuff like that is town meeting, but it's selectmen ratified. Then they split it up, and there's Part 2 now, which is zoning, right here. Part 2, zoning, right there. Part 2, land use and legislation, excavation, site plan review was adopted, and then subdivision of land was updated, and then zoning, the whole zoning was amended here and there. So we can argue this till 10 or 11 o'clock, but I'm going to recommend to the board, our position is this application is valid, and we can proceed with your testimony and so forth of anything you'd like to add.
So,
I can't, I'm not a lawyer, so it would be harder for me to explain it any more than I just did.
I hear what you're saying. I don't agree with it. I hear what you're saying as to what you think Part 1 is, and Part 1 would have nothing to do with zoning. So therefore, the section that I'm referring to of Part 1 would have nothing to do with alcoholic beverages. We know that grandfathering has nothing to do with
Part
that.
1, and what you're
It would have
referring to
nothing to
was
do
your-
with beaches, animals, drugs,
Goddamn.
housing standards. None of that would be the Part 1. It makes
Right,
much more
and that's why this is wrong, not wrong, but this is Part 1, and it's not supposed to be in there anymore. It's gone.
So I think that if you look,
At town meeting, it was ratified, or they've, it's just an old leftover reference that someone's missed and someone hasn't updated. So could we please move on? And that will be decided, thank you, you hang on to that for me. And somebody is going to decide that for us.
so, again, I stick to my position, but as requested, I will move on and will reserve all rights in that regard. So, deeds. Just to prove that we are grandfathered, I did pull some deeds. I'll give them to you. I have Mr. Beckwith's deed, the most recent one, and we checked his property back to 1912 deed in here. There's a 1924 deed and a 1952 deed, all which would indicate that they predate the zoning ordinance and the grandfather, so I'll give you that.
So basically, Benny, that's just clarification that the lot existed.
It's a pre-existing lot. That's the purpose of that. Non-conforming, as defined in as defined in section 175, 175, as exempt under 175-55, although we're
Maybe.
fighting that, but that's the basis of that, so that it can't be later argued that we didn't prove that we were grandfathered and predated the ordinance. So that's why I gave you that. I did hand this board a plan, and I will represent that the plan, we did give it to Mr. Brown. We did try to resolve this before this hearing if we could to save us all this effort. I did give it to the town planner last week, and that's the plan right there. And Mr. Beckwith represents that he will do all the things on this plan. Again, we're trying to resolve the problem that came up at the last hearing and to say what can we do to try to make this a better situation.
Are you going to hand those out?
There's one right there. If you want
That's it?
more.
I would, please.
Thank you.
Thank you.
Okay.
So
I don't have my glasses. What's the date on this?
last week,
Yeah.
Can you see it in here, in that block?
The date? Yes.
9/28.
What is it?
9/28.
28/23.
yeah. So last week.
So in this plan, if I have it oriented correctly, the church should be at the bottom of the paper? The church
Correct.
property?
Yes.
Thank you.
So an argument that I didn't make last time, but I'll make this time, and that is that Mr. Brown does not have any standing to appeal. He's not an abutter. He's not next to an abutter. He's not next to that abutter. He's 3 away. And if we use a first cousin, second cousin, third cousin thought process, he's the third cousin. You know, the Harts are the immediate abutter. They didn't file an appeal. The Furlans, the next person down, they didn't file an appeal. When you walked on the Furlan property, you noticed it was pretty dry. Now, if the water's coming from the top, it would have had to go over their property too, and you would think they'd be wet. You'd think Mr. Hart's would be wet if the water is coming from the Beckwith property at all. So I assert that he's not an aggrieved party, and the definition of in order to be able to file an appeal, you have to be an aggrieved party. And although Mr. Brown and Mr. and Mrs. Brown lot may have some water on it, there's no proof that any of that water comes from Mr. Beckwith. And we talk about plans, he doesn't have any plans. He doesn't have any engineering reports. He doesn't have any designs. He doesn't have any studies. He hasn't provided anything. And this board has sort of been pushing, I think, in the last several years to have people do more of that kind of work, but which I'm usually against, by the way, so I'm on the other side of this one tonight. But I think that there's no proof that you have that he's an aggrieved party and any of that water is actually coming from the Beckwith property. So let me just have you think about something. Put yourselves at the intersection of North Main Street and Friend Street. So you see that intersection, and now look down North Main Street. And it is down to look down towards the Yum Yum shop, all downhill. Now go back to that intersection, look down Friend Street. That's all downhill. And if you walk down North Main Street, all the land from Friend Street to Libby Street slopes to Mill. Every bit of it slopes there. All the water basically goes into the corner where Mr. Brown's property is. All of that water, not just Mr. Beckwith's, not the church above him, not the McCade property above him. It all goes down there. And I was thinking just of the last week that I used to go to Community Bank a lot. And the lot across the street was the Eastman's house. You know, that house that sort of slopes up, all woods behind it. So excellent, material to absorb water. And John Eastman used to mow his lawn much like Mr. Brown did. It used to get stuck right across the street from Community Bank because it was so wet. And that isn't just the only wet lot. You have the Olympia Gym building to the left of that, 2 Varney Road, that's wet. And the church lot to the right of Beckwith Builders and the left of Huggins Hospital is all wet because all that water comes down. And it has been coming down. That's why the town looked at it. That it came up from a question that Luke asked about, the town tried to address some issues on Mr. And Mrs. Brown's property. But I would assert that there's no evidence that you've been presented at all, no facts that suggest that he's an aggrieved party because of this application. The building is already there, fully approved, not going to be taken down. The only question is whether the inside it can have a duplex. And again, that isn't going to create any water issues. So I suggest that he's not an aggrieved party and that there's been ongoing water issues on his lot for years and years and years, have nothing to do with this one building that's been built on this one little lot compared to all that area between Friend Street and North Main where all that comes down. And particularly the church. The church property dumps all that water on Mr. Beckwith. He's not the king of the hill. He's not the top house. He's one down. The church is at the top. All that water hits Mr. Beckwith's property and goes over to that property, which, by the way, was pretty dry tonight. And the Furlan property below that was pretty dry. And again, if there was water coming off the Beckwith property, they would all be wet, I would suggest.
Madam Chair, can I ask Randy a question?
Go ahead.
Randy, is the Eastman property, is that the one where they had a blue tarp on a house and then they tore the house down and put another little one there? There's
Where are you?
across, you would refer to, I thought it was Eastman was the name you said?
Yeah.
Okay, so if I'm at the bank looking across, it's not the one right next to the road, it's the one that's up back?
Up on the hill. Yeah, so if you go to Olympia Gym building, the right used to be Community Bank, now a dentist office. It was the house next door to that.
Right, it was like a small house, and
It was
they
a small,
ended up tearing it down. and-
light blue home.
Okay, thank you.
And that was the Eastman. And that property, again, it had all the woods behind it. You would think that would absorb a lot of water. And it still all came all down there because that was the low lot on that side of the street. And he'd get up near the street and he'd get stuck because it was so wet there. So I want to talk about Zillow for a minute. And it came up now for the third time. And I must confess, I thought it was inappropriate that it came up and was brought up by a board member. And I've always been of the belief...
Could I ask why?
I'm going to get to that.
Okay.
And I don't believe, and I could be wrong, but I don't believe that this board can do any independent research outside of this hearing. That you can only make a decision based on information that's provided through this microphone or provided to you. And if board members do research outside of this, it's usually biased. They're either trying to support an application, they're usually trying to fight it. And I know that I'll say stumbling across Zillow was just that.
Randy, may I speak for a minute? Because I misstated. I didn't just stumble across it, because you said that, and I'm on Zillow, I'm on a lot. But when I sat back and really thought about it, what I did was I was intentional looking for the address, because I knew I was going to be sitting on the case, and I had not gone to the site visit. So I was trying to get a sense of the property. I actually typed the address in, and I was looking for that property to get a sense of the property. So I apologize for misstating. I'm just always on Zillow, and it just, in that moment, I thought, well, that's what I was probably doing. But I was looking for the property intentionally because I missed the site visit.
I hear it. I'm just going to continue on with my...
I hear you. However, it was presented to us before this meeting tonight, so it may be a moot issue.
So I'd just like to drill down on a little farther.
You've made your point known.
I really haven't, actually. But
I want to go back to Mr. Brown is not an abutter. He's not a direct abutter. That's obvious to us. But non-abutters that are directly affected have standing and I knew this, but I didn't know the words to say, to put it in, to say to you, and you know that, standing to an appeal does not apply to all persons in the community. I guess I'm searching outside of the parameters of this meeting, but this is from the Municipal Association that I would have looked up anyway. Standing is a factual determination in each case, considering the factors such as the proximity of the plaintiff's property to the site for which approval is sought, the type of change proposed, the immediacy of the injury claim, plaintiff's participation in administrative hearing, land use. So there's plenty of case law that determines that if you have a direct effect, you have standing.
So I agree with all of that, and I agree with all of that. My point is, there's no facts that support any of that.
Well,
How is he
the
agreeing?
fact is, his testimony, all right, we don't have to belabor
Sure,
it.
exactly. You could take any
We're going to
facts
agree
that
to
are made.
disagree on a lot of things tonight, but it's going to be ultimately decided.
So, just back to the Zillow, the reason that it became concerning is because the inference was made that the site was taken down. And why was the site taken down? And again, the inference was, oh, we got some notice, and that's why he discovered it and he took it down. Not the case at all. So that sort of innocuous comment sort of snowballed into other things. And Mr. Beckwith, got his permit on July 25th or 6th. And so he starts working on it. And he's pretty much done by late August. And so he says that he wants to test the rental waters. And so he runs an ad on Zillow, and you can see from the pictures, if you looked at it, that the unit's done, and he's trying to get it. He gets inundated with calls, communication, responses. Why? Because we have a desperate need for housing. All he's trying to do is a single duplex. There isn't a 24-unit building here. It's a single duplex. Wolfeboro has a need for it, and supportive of that, he gets dozens and dozens of calls, and he doesn't have a CO yet, so he actually pulls it off the site saying this is not going to be a problem to rent this because of the response that he had. But there was a court case, and I'll just say this. It was a Carroll County Superior Court case called Rodowski, divorce case, called Rodowski versus Rodowski. And husband and wife were getting divorced, debating over the value of their property. Husband said the house was worth X. Wife said it was worth Y. They each submitted some information, and the judge was not comfortable with what was presented. So the judge, on her own, did some independent research and went on the Zillow site, which is why my ears perked up, because I always think of that as the Zillow case, and went up to the Supreme Court, and the Supreme Court said, Judge, you can't do that. You can't get any testimony that's not in the courtroom. How does it get cross-examined? If you do your own independent research, how does somebody respond to that from our side, from the public side, not just me, but everybody here? And so they sent it back, and the judge got slapped pretty hard. And because this board sits as a quasi-judicial, which is why I think it applies to you, that you can't do, I don't believe, that independent research. So that's my point there. But it also was used as a timing thing, and that's what troubled me. It wasn't so much the site, that the inference was that he must have been notified, even though he didn't get notice, and that's why he pulled it. That wasn't the reason. The facts were he got so many calls that he pulled it back.
Well, Attorney Walker, when we go into deliberations, this is where we have to sift out what we feel is factual and applicable to the application. Now, that may or may not play into it, but you've made your point known, and I don't know as though that will be part of the deliberation or not.
Sure.
But
And that's
anyway.
obviously your purview, and you'll do whatever you expect, and we know you all are dedicated and diligent, and will do a good job on that. So the application that was filed here cites just one single section, 175.
89.
Doesn't cite anything else, doesn't talk about drainage, there's no section that we could cite. The memorandum that came from the town planner says 175, 89, the notice that goes out in the paper, the notice to abutters, 89, 89, and that's it. Nothing else. Not any other section is cited that would give people notice that that's what was being appealed. So I think anything other than the lot size issue, which again I think is clear under 175, 755, but that those are not appropriate issues to discuss. I don't think that they weren't appealed. And again, we don't have an appeal from any other neighbor but Mr. Brown, not anybody that immediately touches us or even one around on this. So I believe those are the points that I wanted to make. If you have any last questions, I'd be more than happy to answer those.
Oh, okay.
Let me ask a question.
Yeah.
No, you go ahead if you've got something.
No, I was just going to open it up to the public.
Oh, well, I do have a question. So I want to go back to what I was asking Tavis about, and you said save it for Mr. Walker, about the administrative gloss. I mean, because this was like a key point when we were talking with our attorney, is the understanding of grandfathering, and she has a different opinion than you. And one of the things she said is she said, in order for this to hold, you, Beckwith's attorney, would have to show us over time that multiple overbuilt lots have violated the lot size. And so I'm wondering if you can, I mean, you've thrown some things out, but no dates, no size, no specific information.
Sure.
If you have a lot of specifics, multiple overbuilt lots, if you can share that with us.
So I'll address it with one very specific example. And again, I'll rely on Tavis's testimony that 90% of these applications that come before him. But let me just use the property right next door. I don't have to go any farther than this board itself. So let me give you the hard application.
Thanks.
So let me say initially that the Harts, I thought, did a wonderful job with their shed that we saw tonight. They've done a very nice job with their property. But I think their property is indicative of, you can't discriminate here, and the Hart application is identical to this one. So this is the Harts' appeal for a variance. And they wanted to build a shed 1 foot off the line. Now, if you look at the plan that I submitted at the last hearing, their lot is smaller than the Beckwith lot. It's like 0.16, I think. So it's not remotely close to half an acre. But this board didn't even bring that up. They didn't say, oh, you're a non-conforming lot. You're too small. You can't put your shed in. This board itself didn't bring it up in 2020. And you see the application, it says on the first page, your request, to install a 10 by 18 shed within the setback, violates the 5-foot setback. So they filed for an appeal, even though their lot is too small. And just by the way, they're a permitted use as well, an accessory structure under 175-91B. Accessory uses are permitted use. We're under the exact same statute. If you go to the permitted use statute that we're arguing ourselves, it's the immediate line below us for permitted uses. And I believe I handed that out again last night, but it's 175-91A3 says you can have a duplex, a permitted use in the central business district. And at 175-91B, the very next line, it says accessory structures, which is the Hart shed, is also a permitted use, which is what the Harts relied on. The building inspector, and by the way, it wasn't Tavis, that was Matt Sullivan, was the town administrator back then, or the town planner, and we had a different code enforcement officer. And this board, and if you just flip through the application, you'll see that it was granted, and it talks about these sister houses coming through on page 6, all the sister houses right down the street. Page 6, number 1 of the variance application, that it's aesthetically consistent with other sister houses. You saw them all. They look like row houses right down the street, were built a long, long time ago. And this board, on a 5-0 vote, approved the Hart shed, but they shouldn't have if the lot was too small.
There's a difference. The difference is what Mr. Beckworth's issue is, he's making a change to an existing home by adding a duplex. This is saying you can put a new accessory dwelling not dwelling, a new accessory structure. This case is different from this case, and you're trying to make apples to apples.
So
and it's not.
So that's not correct. Section 17591, which you have in front of you, I believe.
Yeah,
If we just start at A, one of the following dwelling unit structures is permitted. A3, one duplex. That's a permitted use in this district. B, also permitted are accessory structures and a whole bunch of other things.
and that was amended in 2017.
Well,
But besides that, you keep saying there's all these duplexes around the area, and I took the next applicant's abutters list because there's more than on this one, and I looked on the town records, and it's all 1 and 2 bedrooms and bathrooms. There's no duplex. There's a commercial, what is it, full belly deli or something. But you haven't handed us book, verse, and page of these duplexes. You're saying that they're around, but I say that they're either pre-existing. I've been on this board, I don't know, too long probably, and I cannot remember anyone coming in for a change of use or addition to their home for a duplex. And the ones that are here are maybe one.
the reason for that is they're always approved. You never get to see them because they're grandfathered lot. They come in. They don't need this board to approve that. That's why they get approved. That's just why the Harts would have been approved if you wouldn't even have known about their shed if they had it 5 foot inside their property. You wouldn't have known about it because it would have been compliant. The only reason that it came before this board, even though the lot was substandard, was because it was too close to the property line. They needed a variance for the setback, not because of lot size.
But I don't understand how it could be approved if it's not meeting, for example, in this one or other duplexes. How is it approved without meeting the requirements of what we require for a duplex? A parking plan.
Could you ask that again? Could you ask that again? Was it of me or Tavis? I wasn't.
Oh, no, I was asking it of
Sure.
you.
I didn't actually hear the question. I'm sorry.
Well,
All right, can we just move on?
okay.
Thank you.
Yep.
I see, I'm going to go with Mr. Hart next, and then Ms. Klein. Mr. Brown will be last. Oh, Mr. Swarfield before Brown.
Good evening again, Dennis Hart, 20 Libby Street. So I actually have 3 questions / points. So the first point is that Mr. Walker said that our property is not wet as a result of what's going on uphill from us. And I'm here to say that things have changed since this project has been undertaken. There is additional mud and silt on my patio, and there is additional mud and silt on my driveway. Understanding that Mr. Beckwith is going to continue to change and do things, but there is no provisions for drainage and things, and I understand that there is a drainage plan. But to say that our property has not changed and it's not wet based on what this project is, I do not agree with. The next question I have is, and I just wanted the question for the record, I don't need an answer right now, but this drainage plan, which I have not seen, it has not been offered to me, and seems like I'm kind of affected by it, but I'm wondering how the stormwater from the bottom of the property is going to get to the storm drain. As you guys saw tonight, we put our retaining wall in. We put per code adequate drainage. We tied it into a system to go out to the storm drain. I'm getting that checked by the DPW to make sure that we're compliant, and I'm just wondering how that's all going to. And I guess as the plan matures, those things will be answered. And with regards to the question about the our appeal to the variance with regards to the 1.5 foot setback, or the 5 foot setback versus the 1.5 foot setback. I would say that, I mean, we're talking about a shed. We're not talking about a duplex with parking and drainage and those kind of things. We're talking about a shed. So, you know, the fact that ours, and I understand there's a lot of procedural discussions going on, and I'm not I don't know these ordinances and things like that. But when it comes right down to it, things have changed based on this, because of this project. And that's really my statement from now. And I am wide open for questions.
Madam Chair, may I ask?
Yeah, go ahead.
I just have a quick question from the viewing that we did today. On the left-hand side of your property, there was...
I'm sorry, looking from the street,
From
going
the
to
street.
back?
Looking to the back of your
Okay,
lot.
yep.
Left-hand side of your property, you have your metal sheets there that form a barrier.
No,
and
the metal sheets don't form the barrier. The
Just-
6x6 pressure-treated lumber.
lumber that's behind it,
Yeah,
actually.
and I put the sheets on there.
That's
It's
just for
aesthetic.
looks.
It's
Okay.
just looks, yep.
And then we walked further back, and there was a lot of silt and stuff there. How long has that been there?
It just started. I don't remember the exact date it was, but I can find that date out for you. But it was probably it was after the September 11th hearing. We had a big rainstorm, and before Mr. Beckwith installed that riprap stuff, he had raised that level of behind that cement block retaining wall. That has come up. I don't know exactly what it is. At least 3 or 4 feet, something like that. Okay. And we never had that issue before. It all kind of went elsewhere. It didn't come funneling down into our driveway.
Okay. I just did not remember it from my previous site walk. That's why I was asking.
Yeah, it was there. Yep.
Okay, thank you.
Thank you.
Yep.
Everyone all set with this one?
Anybody else?
All right, then I think I said Ms. Klein next.
Hi, Audrey Klein. I'm here representing Roger Kent, a direct abutter.
No, we're not doing Mr. Kent. I thought you wanted to respond to the Brown.
I am. I'm
She's
in
identified
support of Brown's appeal, and I'm representing the abutter.
Oh, I see, okay.
Okay? And I'm doing this because I don't know whether I'll be saying all this again later or not, so I want to get it in there, and I'm going to get it in there. I think Attorney Walker is counting on this non-conforming section, and he's said it many times how important this is. And I think we can talk about empty parcels and what their non-conforming allowances are as zoning theory for a long time. And I love that. I could talk about that all night. The fact is that has nothing to do with this case. And the reason is because this parcel has an established use as a single-family dwelling. It was established before zoning. So it has a use as single-family, and in order to change the use to duplex, it needs to meet the new standards for that for that new use. So if you think about it in a bigger sense, you wouldn't expect to be able to take a single-family dwelling that's been there as a established use and change it to some other use without reviewing the code, the zoning at the time that happened. You can't change it to a multifamily because it's been there, as a non-conforming lot. When you change the use, you have to meet the zoning that's in place at that time, and that's exactly what's happening here. That's much different than a shed, which is an accessory use to the single-family dwelling, does not change the use of the parcel. In fact, an ADU in our zoning does not change the use of the parcel. They specifically say that so that we know there's no change of use with an ADU. However, there is a change of use with a duplex. And so that is the difference. We don't have to go into all this discussion about, how many parcels have changed over time. In fact, what if I said wasn't true, we would never have all these increases of the requests for increase in density for these existing lots. We would just have them increase it because they were there before. But we don't, because every time they change, they have to go through the process that is required in today's zoning when they make a change to a lot. And that's the big difference. Also, I wanted to talk about the other point that Attorney Walker was making with regard to the Brown application, is that he's trying to make you believe that you can only talk about the couple of things that were on the application. So looking at Laughlin, which is kind of the zoning Bible that people refer to a lot, looking at the ZBA standard review in administrative appeals, what Laughlin says is there is no statutory provision that expressly authorizes the ZBA to review appeals from decisions of administrative officials de novo, and that means from the beginning, like new is de novo. However, RSA 674-33-2 confers upon the ZBA all the powers of the administrative official from whom the appeal is taken. When hearing and deciding an appeal, therefore, the ZBA is authorized by statute to step into the shoes of the administrative official. Although the words de novo do not appear in the statute, the authority to act as the HDC is its functional equivalent, and then they give a town of Hinsdale versus town of Chesterfield. De novo review means that the reviewing body decides the matter anew, neither restricted by nor deferred to decisions made previously. So you are not restricted only to what's on the application. I think I went into this last time, and this...
Can you give us that statute again? 743? What?
This is 674-33, which is just the ZBA's authority to hear
Oh,
appeals.
okay.
That's all.
Okay, okay.
But
Excuse
it
me.
was being explained.
Didn't you also cite 674-34-2, I think?
I don't believe so.
Oh, perhaps I misheard the
I
number.
read it in the beginning was,
So Laughlin is opinioning on the scope of the review that can be had under 674-33.
right here. Yep.
So just going back to the change of use. So the change of use from single-family to duplex. So what the permitted uses are single-family, accessory structure, or duplex. The accessory structure does not change the use of the property. It's still a single-family dwelling, but the duplex does. And in section 175-129, it says that it goes into the change from one type of use to another unless off-street parking spaces, et cetera, have to be reviewed. So, and that also is the paragraph that says about the increased footprint, the erection of a new building, and the development of a use not located in a building, which would be a parking area, a patio, or anything of that kind. I think that's all I have for now. Do you have any questions?
Yeah, I have a couple, actually.
Yep.
So what you stated in the beginning, like the part where you said through the process,
Through the process?
Tavis acts as the agent, was the planning director for the town of Wolfeboro. So through the process, Mr. Beckwith submitted a building application. It went through the process. I just want to be clear that it's not like the permit didn't go through the process. It did go through the process. It's being appealed. The process is being appealed now, but it did go through the process.
Okay, I don't quite remember saying that, but I believe you.
Yeah, and then where you cited Laughlin and our ability to look at the entire project, basically. So basically pulling it all, potentially looking all the way back to when the initial building permit was issued for the garage.
It's hard for me to say because
But-
they're so mixed up, but. yeah.
Correct. So basically, you would, I mean, potentially, at that point, someone could come here and be like, I want to advocate for, once again, an application that went through the process. Someone could argue, you know, hey, like, I think this thing should be torn down, you know, even though it went through the process. I mean, I just want to make sure that, you know, if that, because you're here on behalf of Mr. Kent, and you're advocating right now on behalf of Mr. Brown, is that your intent, that the project would go all the way back to being torn down?
I never
I'm just
said that,
asking 'cause
nor
that-
do I think that, no.
Okay, I'm just asking, because I want to
Yeah.
just clarify.
No, my intent, and I think I spoke about this last time, was that the zoning lays out what we believe should happen in town. And in order for that to work well for everybody over a long period of time, the regulations need to be followed. And that means a stringent adherence to the application process, the zoning requirements, in order that everybody is meeting the same benchmark. I don't think it should be torn down. I think it should go through the process with everything addressed.
Okay. This brings up a good point, and this is the time where I wanted to bring it up. This is our building permit application here in town. When you come in to do a building permit as a layperson, this is what you're handed in the department. And one of the things that came up, and it's very interesting, is this 30-day appeal window, okay? And this could be just the town of Wolfeboro's fault, okay? But if I come in and get one of these, and there's two right here, Tavis went down and got them for me. Nowhere in this permit application does it say, for the applicant, does it say you have a 30-minute appeal window, 30-day appeal, 30-day appeal? Okay, so if you're a layperson, you come in and get a permit, and then this thing gets issued to you, signed by planning director or the, the building inspector. They hand this to you. If I was handed this, I'd take this and slap it up on my door, and the next day start building.
Yep.
So I want to be careful where we go with, because the process, to me, you know, we can look at the process in hindsight, but for the person that the thing is being appealed upon, you know, I would feel that they felt like they went through the process. And whether or not the planning director, in our interpretation, in the end, did the right thing, I just want to be careful that we have an applicant that went through the process they believed they were going to, and they were submitted a permit.
But I want to add
Wait a
that
minute.
according to our attorney, because we discussed this, she says he has acted at his own peril. He started construction fast after the permit was issued. It's like you can't just say, well, you gave me the permit, and therefore, I mean, there's an appeal process. Mr. Brown is following it.
Oh, I agree.
And so part of that is also just because even if we stated there's a 30-day process for appeals, it's based on when did the neighbors or the abutters know that there was an issue, not when the building permit was issued.
I don't think that's what you're saying. And sorry for interrupting you. I think what you're saying is somebody's gone through the process. They have a piece of paper that says you're good to go.
Correct.
And that really should be true. That's the problem. That should be true. It's not true in this case because there wasn't a diligent review, but also the state law says that the contractor is responsible for all the compliance with building codes and zoning codes. And so even if the building department misses something, that doesn't mean it's okay. And it's unfortunate that sometimes that happens, even in the best of worlds. It's unfortunate that some contractors go through that, but that is the ultimate responsibility.
I have a question.
Are you done, Luke?
Yes, I am.
Yeah, I've got Sabette, and I want to say
have a
something.
question,
Not
too.
Sabette, I've got Kate, and then I wanted to respond to something you said. Go ahead.
I just have a question.
Speak up loud.
I have a question for Tavis. Prior to Mr. Brown's appeal, I'm just wondering how you came to approve the duplex when you see the dimensions. There's a big difference between the size of the duplex and the actual original house.
17555 says that frontage and lot area does not apply to a grandfathered lot. The fact that there's currently a Part 1 reference that should probably say Part 2 now would disassociate the rest of the ordinance from itself. So it was brought up tonight, but I think it's a fool's errand to go down that path. So to that end, lot size is typically used, I'm not speaking to Brown or Kent or anybody else, lot size becomes a relevant factor if somebody is doing a subdivision or doing a boundary line adjustment or something like that. If somebody has a legal lot, and no one has ever challenged the legal lot in this case, then that becomes the legal lot upon which you can do a permitted use, provided you can meet setbacks, which is what the entire section says.
I'm not talking about the lot size, I'm talking about the square footage inside.
Square footage in-
Definitions, our attorney says that definitions are not grandfathered, and the definition of a duplex dwelling is more or less equal size units.
Actually, it doesn't say that at all. It says
Pardon?
proportional. And I think if you look at the upstairs and the downstairs of the garage that was
More or
explained
less.
to me as the duplex is about equal to that of the house. The ordinance does not say the living area has to be a proportional size.
It does say that.
It does not say the living
says-
space needs
So
to be
am I
proportional.
excused from the podium if you guys are going to discuss amongst yourselves?
Well,
or is there
before you
another
leave,
question?
I'd like to know if you have more to
Please,
say.
wait a minute. One at a time. Audrey, you wanted to respond?
No, I don't. You
Okay.
all are talking and I can sit
had wanted
down.
to say something, and now
Okay.
I think I've forgotten. What it does say is a building, a duplex, dwelling duplex, a building and accessory thereto principally used, designed or adapted with two dwelling units of similar proportion. I think that's what Kate was trying to get at.
Correct.
And to Luke, the application is definitely lacking. However, it does say the board, I guess it's the Board of Code Office, the board strongly recommends that you become familiar with the zoning ordinance for relief. And it's the same for a subdivision, the same for anybody that brings anything before us. Our form also says the same thing. You were asked to be knowledgeable and seek out the advice that you need to have a successful application. So there's a certain burden upon the applicant as well. And then, and there is a time frame. Appeals must be filed within 30 days of the initial decision. Well, I don't know what the initial decision is, but that's not defined. So I will go along with you on part of that. Okay, thank you. Is that all, Audrey?
I was only waiting
Is
for
that all?
questions from you
Okay,
all.
we had, thank you, we had, I think it was Bill that was next.
Sorry, I don't want to take up any time, but I did want to corroborate what Mr. Brown said. When they rehabbed Libby Street several years ago, the back parking lot at the Kingswood Press, which faces Libby Street, was, we'd always had a problem there with water running down Libby Street right into the press parking lot, creating a hazard there in the winter with ice, things like that. So I talked with David Ford about it when they did the construction on Libby Street, and he did put a culvert in right at the bottom corner of our parking lot at the same time that he worked on Connie Brown's driveway. So I just wanted to get that out there. It may not be in any file anywhere, but that did happen. And based on what was said earlier, I do recall last winter in particular that Libby Street was very icy, and it was coming from Bob's cellar, from the hose that came out there. So it was pretty treacherous sometimes going up there. So I would hope that whatever drainage you folks saw or were told about that he's doing to mitigate the problem will also help his cellar and hopefully that will go into the storm drain so it doesn't go out on the street this year. And the final thing I was thinking about this week was exactly what is the definition of a duplex. My understanding, and when I Googled it, it was all talking about either upstairs or downstairs of one building or a left and a right side of one building on the same floor. So I'm just confused as to this garage apartment, to my mind, doesn't follow what I was reading when I Googled it. Now, the town's definition may be different than what you read online, so I was just wondering, I'm sorry if I'm confused about that, but I just thought I would bring that up to straighten myself out, so thank you.
Would you like to hear the definition of a duplex?
For the town, yeah.
It's a building and accessory thereto principally used, designated or adapted with two dwelling units of similar proportions, the living quarters for each of which are completely separate, a single-family dwelling unit with an accessory dwelling unit is not a duplex unit.
So is this a duplex unit or an ADU?
ADU is not in this discussion at all.
Okay. So the house is 2 stories and the apartment is 1 story?
Apartment is not a duplex.
I mean, the duplex over the garage, I'm just wondering, it's a,
Well, it might help, a single-family dwelling, a building and accessory thereto principally used, designed or adapted as a single dwelling unit. The addition of an accessory dwelling unit to a single dwelling unit does not change the status of the single unit to a duplex. So you have to put the two of them together. That's it. I can only read you what's in front of me.
okay, that's fine, thank you.
Okay. If we're all, oh, I'm sorry. Well, no, Mr. Brown.
Good evening again, Derek Brown, 30 Libby Street. Just to recap on a couple of items. Mr. Chair, would you happen to have my application right there, page 4, where what I defined my appeal as?
Page 4.
Oh, this is what we had you read last time? Yeah,
I think it's
okay.
page 5, dear. Yep.
I like to do this for the benefit of the room as well as specifically Mr. Walker. And I apologize because I did not have the article name specifically. On my appeal, I wrote, the applicant states the decision or the reason for the appeal. 1, Article 175-89, the lot size. And then point number 2, and it's spelled out specifically, point number 2. And I did not have an article number to refer to. Erosion and drainage impact per the public hearing of Schedule July 11th, which was canceled and not rescheduled. So that was the basis of my appeal.
And,
Now, specifically,
excuse me, Mr. Brown.
yes, yes.
You actually had other information on here. The decision to be reviewed is as follows. Approval of permit number 20230000468 to be redefined as duplex, and then you had a map number. So
Okay.
that was
Gotcha. Thank
all
you.
the text.
So a comment was made earlier about me being the only one up here from the neighborhood speaking. I had a personal interest in this. My mother has been fighting the bad building practices on Libby Street for a lot of years alone. I have already mentioned that. I'm not going into that again. So I have spent much of the spring and most of the summer trying to chase proactively what is happening in the building department with regards to Libby Street. Lack of information, and in quite honest, again, my opinion, misleading. So as someone trying to find out what progress is being made with what paperwork, with which board, and what permitting has been nearly a full-time job. It is not coming freely. And most of the neighbors have not been directly affected because they're not at the bottom of the hill. I hate to make it so fundamental, but if you pour water down your driveway, it goes to the bottom if it's a slope. If it's a lot of water, you might leave some water along the way. So lastly, last item. I have said repeatedly to anybody that attended planning meetings, I am not here to say Mr. Beckwith's building should be torn down. I never said that, never have said that. What I have said is follow what's been asked of the code and the articles and good building practice for drainage. If you ignore it, it's going to add to my already concerns of water. I have never stated he is the sole source of the water. I have stated he is a significant contributor coming. I can't afford any more. We're trying to fix what we have right now without adding to it. That's all I've got to say. Any questions?
Nope, thank you.
Okay, thank you very
Mr.
much.
Hart?
Yes, just one more question. With regards to the square footage of the duplex, is the square footage of the garage as well as the apartment of the garage considered as a total for the duplex, which would mean that the garage would be used by the duplex people and then, to the benefit of the duplex? That's my question, is the duplex considered the garage and the apartment above? If that's the case, then the garage should be available for the use of the people that would be renting. That's a question.
I can only say he has a lawful permit for a garage.
And
Per
it
the
doesn't
plan.
matter which
I
dwelling it's being used for.
I can't elaborate on that.
Okay, I wanted to ask that question.
Okay, Mr. Walker, Attorney Walker.
Anyone will do. Three things I'd like to give the board, just more plans that I gave you. These are color-coded. Number two, the table of contents for Wolfeboro zoning ordinance dated September 25th of 2023. So that's part one. And then all the way at the end, part two doesn't start until historic district to go back to 150, 75, 55. That's where I'm getting it from based on that information. Number three,
Can you
this
say
is
that?
it.
Whoa. Can you go back and say that again slower? Because I couldn't quite hear you. Sorry.
Sure. So this is the September 25th, 2023. If you go on the website, this is what you're going to find for the table of contents, the Wolfeboro zoning ordinance. And it talks about part one, part two, part three, and part four to go all the way back to 175-55. But that's what's on the website last week, which is what I relied on in coming here. So I'll give that to the board.
And that was from the 2022?
2023.
Last week. So last week's, and again, if you look at those, you'll see it very clearly says on the first page, part one, and then you go all the way up to section 192, which is after the commercial central business district. You get up to historic district, that's part two, et cetera. That's what I believe 175-55 refers to when it says part one, part two.
Well, but then I said it's superseded by 2017 amendment.
You did. I just want to submit that because that's what I have.
This is part of the problem, is the inconsistency, and somebody else beyond us is going to have to settle it.
Well, if I'm struggling with it,
If you're struggling with it,
I'm not saying
you know
that I'm
I
better
am.
than anybody, but I look at it probably a little bit more than the average person, and that would be
We can agree
highly
to
embarrassing
disagree.
if that was a problem. This is just to just go back to the water. Bill mentioned it. Mr. Beckwith was pumping water out of his own basement this winter because the house above him pipe broke, and this just reiterates that.
What is that?
Can I see?
It's a letter from the Water and Sewer Department because the water was just spewing out that basically says, there was a problem, it's been addressed, it's been fixed, but that's the reason. It wasn't Mr. Beckwith just pumping water onto the street, it's because the uphill property was causing him problems.
Yeah, Luke, give it to Luke. He's the
I
one that's
will.
in charge
They go
of that.
together. Yeah. And then just,
I understand what he's saying, right? You don't understand what he's saying about that? That a pipe burst at the neighbor's house?
Yeah.
And that's a letter probably stating that that's what happened.
Exactly. Wasn't Mr. Beckwith just dumping water on a Libby Street? It was water that he didn't create that came onto his property. And I'm just making a point because Bill brought it up. You know, again, it made it look like
All
he
right,
was.
we'll just add that to the record.
Yes, thank you. And then just the last point that I'll make is Mr. Brown's application, he cites one section, 175-89, doesn't cite anything else. And I've been listening now for 3 hearings. I didn't go to the first one, but I did watch it. What section other than that is he referring to? And I still have not heard a section number as to what he's referring to.
Well, I would respond that although there's an obligation, I've already said that, upon an applicant to do his due diligence, we still have a lot of lay people present before us, and we, at least one member here, takes the whole application in consideration. So we'll have to see how that works out. But, Luke, will you put a date on that, please?
Just on that point, and we have a similar situation. We have Mr. Beckwith who applies, and to go through the process, he gets his permit a year ago for a garage, apartment, and deck, gets it all approved, certificate of occupancy. Nobody's appealing any of that. So that building is there. It's not going to come down. But there then is an appeal of the duplex part. And again, he went through the process. He got a permit. You can see that it's finished. He spent a ton load of money to get it ready, and he's shocked that we're even here tonight through, again, no fault of his, and again, I'm not blaming Mr. Brown either here. The process could be a little easier, but he is equally innocent, I say.
Well, I guess that comes back to what Luke was trying to touch upon, is the format or the application process, the ushering of a person through the process. Enough said.
May 3rd. The letter's dated May 3rd.
Okay. I'm just going to put that in the file, the date on it. 10/2/23. 10/2/23. All right. Is there any more public comment from anyone in the room before I close the public hearing? Is there any more questions for Mr. Brown or Attorney Walker before I close the public hearing? I would entertain a motion to close the public hearing, and a roll call vote will be had.
So moved.
A second?
Second.
Roll call.
Yes.
In favor? In favor of closing the hearing?
Oh, yes.
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 Okay, the hearing is closed, at which time we do not take public comment. We do not reopen the hearing once the deliberation starts. Okay, now, all this paper in front of me, I don't know where to begin. There are certain things in this deliberation that I feel we should not consider. What we have heard about the procedural issues related to the planning board application, it's now irrelevant. Complaints about the procedure and other issues with the planning department in general is not to be considered. Historical decisions or lack of action regarding drainage is not under our purview. It's not in our jurisdiction. Whether the property owner has continued construction after the appeal was filed in violation of 676-6, the ZBA has no enforcement authority and cannot weigh in on this issue, and we had said that previously. Any specific interpretation, application, or construction of the terms of the zoning ordinance made by Mr. Austin in issuing the building permit that were not raised by Mr. Brown, who is the person who actually filed the appeal in this case, if any, of the other abutters or members of the public raised new specific challenges of this nature, they are not part of this appeal.
Would you reread that, please? Would you repeat that? I don't think I got all of it.
All of those again?
No, just this last one.
The last one. I had trouble with that one. These are items that are not relevant to this appeal and that does not have jurisdiction. We do not have jurisdiction over them. And the last one was any specific interpretation, application, or construction of the terms of the zoning ordinance made by Mr. Austin in issuing the building permit that were not raised.
Okay.
Were not raised.
Anything outside of it.
Like we can't invent something new.
Gotcha.
Who was the person that actually filed the case. If any of the other abutters or members of the public raise new specific challenges of this nature, they are not part of the appeal. Then these are some of the things that we have jurisdiction over and we should consider within our deliberations. Any construction, interpretation, or application of the terms of the zoning ordinance that were made by the administrative officer in the course of the issuing of the building permit under 676.52B, as a result of the ZBA needs to be sure that it confines its analysis to whether the ordinance was properly applied, properly interpreted, properly construed to the building permit application. You got it. I'm not. 676.52B. I think one of the bigger questions is the project of duplex as defined in the zoning ordinance. Looking at the appeal by Mr. Brown with the appeal of, let's see, no, that's not it. Skip that. Minimum lot size. Mr. Brown has challenged whether the administrative official properly applied the requirement of 17589A2 regarding minimum lot size duplex to specific project proposed in the building permit application. And so we have to ask ourselves the question under that 17589, is there for duplex in our ordinance a minimum lot size for duplexes? That's the question you have to answer. And then does the property have the minimum size? It's a question you have to answer. Do we have any waivers to that? No, I don't believe we do. Erosion and drainage impact. Mr. Brown has referenced stormwater management plan. From what I could see, the stormwater management plan is for non-residential development. That in of itself may not apply, but whether the drainage created for the parking may apply. These are things you have to decide and think about. parking spaces. It's been argued by Mr. Brown that 175, 129, and 175-36 of the zoning ordinance has been argued that the administrative official improperly applied or interpreted the parking requirement. This is something the ZBA can rule on if it involves an interpretation of when the provision applied and application of these provisions to be permitted. Let's see if this one, and the last one, which I've opened all the meetings with, is the statutory authority of the zoning board to revoke, reverse, affirm, wholly or in part, modify the required decision of a determination of appeal from the administrative official, which would be the building code person. If you find that there's any result of a mistake, the permit was improperly granted, the ZBA may reverse the decision and revoke the permit. So, where to begin? Give me a minute or two. Go ahead.
Because this is an administrative appeal, do we follow those same, we're not following the same process and questions that we do in other situations? So is there a specific
I
process?
just read off the things that we
Right.
have to decide.
Okay, each one of those?
Pardon?
I've got you then. I understand.
Either you feel that it was interpreted correctly or it was not interpreted correctly. And
Okay.
I think, to me, two big nuggets are stormwater management issue versus just drainage. And the other big issue is lot size and the definition of duplex. I think those are the crux of it. Luke, you got any ideas here?
I mean, I think everyone here, by this point, must have in their mind where they think they're going with this to some extent. So I don't know how you want to hash it out. I mean, I know how I feel about parts of this issue, about many parts of this issue. I've kind of voiced some things that I've, definitely have problems with. It was funny, one of the things you just brought up a couple minutes ago, we're having trouble even interpreting some of our own ordinance. It's not our fault. I mean, whatever Section 1 is and whatever Section 2 is, that's a disaster. I mean, that needs to be dealt with going forward. We have issues in our, in our own guidelines that are hampering our ability to be able to look at things, in a cohesive manner. That Section 1, whatever that was or is, and whether it was amended or isn't amended, that's something we're going to be arguing over tonight and beyond until that gets remedied somehow. I mean, I have some major. I'll start off, sure. Mr. Brown definitely has water issues. Definitely has drainage issues, no doubt. I like to kind of think about this as in a chronological order of facts for me. This is how I thought about it literally all weekend, and I shouldn't be thinking about this all weekend, but I did. It's a pretty big case, and it's a really tough case. But, I try to think like how I would feel as one everyone in that community and the applicant. Okay, so I think first is the applicant, and I say, I come to the town of Wolfeboro and I get a building permit for a garage barn. The building permit's issued, and I build my garage barn. And then, somewhere along the way, I said, hey, you know what? What a great opportunity. Wolfeboro is in a housing crisis. Like, I can make some money. Let me put some living space above it, a duplex, whatever you want to call it. And I come to the town once again, and the town gives me this thing, and I fill it out, and the next day, it gets signed. And even, I was going further, on the first page of the thing, it says, construction not authorized until permit is approved. 24, But I understand that, the average person should at least make themselves aware of the zoning ordinance. But we're arguing over parts of the zoning ordinance that we don't even know what they mean, definitively. So I can see how that can be a very frustrating situation for an applicant that came and met with the town administrator, basically, our planning department. They said, this is your permit, you're good to go. I understand it can be challenged, but there's a long road for that.
Here's the but. You just said but. Complaints about the procedure and other issues of the planning department. That is one of the things that we're not authorized to judge. We have to go back to the application, 17589, and the board has to decide about that page 5 on the application where he talks about drainage, and decide on the substance of what's been told to us. And, does it meet the definition of a duplex by size? Does it? We've already heard. I read, I don't know where I read it now, but that I guess I read it right here.
Proportional.
It's supposed to be equal.
Well, proportional, whatever that means.
Proportionally equal. Well, we know that's not the case. It's 728 square feet, I believe. And the house is, I had that number somewhere, the existing dwelling is 2,000 and something square feet. So we know, we did the site visit, we know they're not proportionally the same. These are the kinds of things we have to address, not the problem with the planning department. Yes, Sarah.
Okay, relative...
Speak loud so I can hear you.
Oh, I'm sorry. I'm always telling Kate to use hers. I should use mine. We do know from our viewing today that when you come to the relative size and what's being used in that new part of the building, that the owner is planning on using the downstairs garage section on the right to store lawnmowers and all kinds of stuff like that. So it would appear that perhaps that's not going to be at the use of whomever is upstairs. So we can't really consider both floors even, really. But even without that garage not being used by whoever's renting or staying at the duplex or whatever type of plan they have for renting it out, we know that it's an even further reduction and an even greater inconsistency with that duplex being of similarity for size.
I don't quite understand a portion of what you said. I heard it, but I didn't quite understand it. Are you calculating the size of the garage underneath the apartment as part of the duplex or part of the residential property, the house?
The resident said he was going to be using part of the garage, so that would not be considered part of the duplex user's square footage in that case.
Okay.
So I'm thinking that would be an even greater reduction into whether the duplex was of similar size to the residence.
Okay, and we have the plan of, I think it's 2022 that is provided with the building permit, and it's written in the duplex is 728 or something like that. And then off the tax card, it gave a square footage for the residential quarters as, I wrote it down here, I can't find it now, it was substantially more. So those are the kinds of things that I think we need to rely upon. I think it's the dimensional controls under 179-89-2, the definition of duplex under 175-175B. I'm not sure how I feel about drainage. There is a reference on parking, Sabet parking. You got anything to say on that?
About the parking?
Parking?
Well, I want to back...
As to the parking change of grade and drainage.
As to the parking change of grade, well, there's no, what we don't have, I mean, what I go back to is a duplex requires a parking plan. We don't have a parking plan. There was no, I'm just looking at the hard cold, what it says goes with when you apply to build a duplex or to create a duplex, you must submit a parking plan for 2 spaces. That was not submitted. So, and what's framing my thinking a little bit, and I'll just share this with you, is that I went back and looked up zoning administrator and what he is charged with in terms of interpreting all of this, because it is there's a lot. And it says that the zoning administrator is charged, he should take the most conservative or restrictive approach in applying or interpreting these regulations. And in my thinking with a lot of this, what we've got is not the most restrictive approach, not a conservative approach that looked at what protects the neighbors and also what protects the builder, to give him the information he needed and to protect the neighbors. There was a lot of information that he knew before it came to ZBA. So with everything, I mean, so when you're asking me, what do I think about parking? I think the conservative or restrictive approach, where I'm sitting in his seat, would be to say, in our ordinances, no matter what's confusing about whether it's a conforming or non-conforming lot or whatever, the conservative approach would be to say, okay, let's go by the books as much as we can and require a parking ordinance, a parking plan. So I don't know if I answered your question right then.
It does. All right. I think that, oh, Sarah, did you have your hand up?
I just wanted to follow up to something. It says, you know, we don't have one now, but we have to put ourselves in the position of the person that was making the original decision to approve of the building permit, and they didn't have one either.
Have a parking plan.
And no, the codes enforcement did not have the parking plan.
Right.
We don't have a parking plan.
Right.
And then the question is, should it have been permitted if all of the items weren't there? And this is just one item that wasn't there.
Right.
It should have been. And there's, you know, discussion on both sides of whether the lot was grandfathered or not. But duplex isn't grandfathered.
No,
No,
it's not.
So we have to remember that as well.
No one is grandfathered from a definition. No parking plan was submitted. And within the definition of a duplex, it says you're going to submit a parking, two parking spaces per dwelling unit.
What we also have to do is, along the lines of what Sarah was saying, what we have to do is, we have the authority to reverse, affirm, and hear and decide the appeals of an alleged error of the administrative official. It's not an error for the applicant. It's not an error that we know of. Well, I'm not going to say that. Was the building inspectors or the planning department's interpretation and understanding of what was required, did they have what they needed to have? And did they interpret it correctly? And our job now is to say, did they or didn't they? And I think it's pretty clear that what did I have? The lot size under, let me find it.
Doesn't meet the
The lot size, 17989A2. Anybody got that in front of them?
I don't know.
179.
79A2.
I gotta find it.
It was 0.5. 179.
What would I say? 17989, A2.
$80
175, section 89.
That's dimensional controls. 170, did I say 170? 175, I'm sorry, 175. No, wait a minute.
175-89,
89. I wrote it down wrong.
Section A,
Section
number 2.
A2,
Right.
all right? So,
Yep. That's the lot size, yep.
in the C1 district, a single-family dwelling or duplex requires a minimum lot size of 21,780 square feet, a half acre. This parcel is 8,712 square feet, 0.2 acre, which does not meet the required minimum lot size in the C1 CBD district. So the question is, does it or doesn't it? Fact?
I think that one's that one's all up to interpretation to me.
That's the one that has to do with the grandfather, what?
Where it refers
You know-
back
you know,
potentially is where-
I'm sorry, the grandfathered thing will be ruled on beyond us.
Beyond us, right.
We're taking this
At face value, what we see on the paper.
as what?
At face value. I mean, what we see written on the paper, on the page that we
information we've
have.
got.
Right.
We have to make that decision. So I think that is the main thrust here for one of the things that, well, let's go around the table.
Okay.
17589, A2. Do we believe that the dimensional controls apply or are correct to allow a duplex?
Were they applied correctly?
What?
You're saying, were they applied correctly?
Right.
I'm not saying were they applied correctly. Do we believe they have the required lot size to have a
Okay.
duplex?
Okay.
That would be the question.
My answer would be yes.
You think they do have this?
I do believe they do, because I believe the zoning ordinance is that ambivalent and that ambiguous that that's the crux of everything we've discussed tonight is that part of the zoning ordinance is completely worded in such a way that I have no idea what to think, but it could refer to the whole, originally it could refer to all of section 1, and if it does, and if that's the way, hypothetically, the administrator's been using it for the last 3 years since he came on, and previous administrators, then that's why the permit was issued, I believe. So I take the benefit of that.
I don't think the ordinance could say it any clearer.
I think there's two issues here. I think there's the issue of the math, and then I think that there's the issue of the grandfather thing in part 1. And I think we can all agree that .5 and .2 are not the same.
Correct.
Okay, so that takes care of that one. The dimension is lacking by 3/10. So now we can move on to the other parts of the
Do
question.
they agree? Sabette, you would agree with what Sarah's describing?
Yes, I do not believe the lot size conformed.
Just the math.
Just the
is what
math.
we're talking about. And
Just the math.
And
Do you?
he
The math on the lot size?
is inadequate because it's not .5, it's only .2. Okay.
So did Luke change your answer?
No.
based on the math?
No, that's two
Because then
issues.
the grandfathering comes in.
Right.
The grandfathering allows, because if it was a new lot where you were building a new place in the C1 district, that .5 for me is golden. Okay?
It's not a new lot.
Correct, that's why I believe
And
it's exempt.
It's a change to that lot. It's a change to that lot. If we were putting a new house with
It would require a half
duplex,
acre.
then, yeah. But no, this is a change to that duplex on that lot in that zone.
Change to a single family, to a duplex, yes.
Single family, yeah.
Right.
All right, I have a approximately 4-to-1 lot size.
No, he agrees.
I thought he's disagreeing.
I agree on the lot size, I don't agree on the grandfathering.
Oh, I'm not talking grandfather.
Right, we're talking about the simple math.
I believe-
Is .2 equal to .5, and everyone has agreed no.
Right.
So now we can move on to another,
The next one is 175, 175B. This is maybe what you're thinking. Definition duplex. Again, 75, 175B. This is where your part 1 and part 2 comes into play, I think.
not yet.
Definition duplex requires 2 dwelling units of similar proportions. The duplex is approximately 748. Oh, here I've got, the town record tax card shows residence living space at 2,400 square feet. And then you can see the plan of 9/27/22, which will show the disproportionate that we got, and it's in the file. So that is in 175, 175B. It's spelled right out. I read it before. I don't think I have to keep reading it.
No, you don't.
So, an opinion on that? Sabette, you want to go first? Do you think that the definition of duplex, by the similar portion of that definition, do you think these are similar proportion?
No, they're not.
One is 7.
It does not meet the definition of a duplex, as stated in our code, in our requirements.
Sarah?
I
It's a-
agree with that and with the advice we have about this piece right here.
Yeah.
It doesn't match.
It what?
It doesn't match.
Okay.
It
Kate?
do- It doesn't meet the definition of a duplex,
Right.
right? Okay.
What did you say?
He hasn't yet.
I haven't, because I don't feel that the duplex issue is personally relevant to this particular case.
But they applied, the whole case hinges on.
We can hear you.
I-
I can't hear you.
I was
Go
just
ahead.
saying the whole case hinges on it was a building permit
does,
for a
and-
duplex, so how could it not be relevant?
Well, because that's not the argument that is being, if we're always talking about being 100%, dealing with the case itself, that issue was not the fundamental problem in the appellant's appeal.
Okay.
Was the duplex. I mean, it is. Do I think if you're looking at it strictly from a proportional sense, one to the other, I don't know what proportion is. I know that this was not what the applicant applied, was not what the appeal is about. So I don't know why,
But
because we could get into a lot of other issues.
Could I say
but-
something to Luke?
Yeah.
But Luke, I think what Suzanne's trying to have us do, that I appreciate, is I think she's trying to have us drill down on these things step by step by step by definition,
Sure.
coming back to a final conclusion.
Sure.
And then,
It's not proportional based on the zoning that we currently have, correct?
Have you got the piece of paper we got today from the attorney? Tonight, I gave you
I do have it.
the last one. At last, we folks look for the attorney's,
This is the one about the Part 2
the
stuff.
letter that goes with that.
This one right here?
It might be.
there's a lot of paper.
I
This
know.
one?
Nope, not that one. Just came in tonight.
That was about the Part 1,
5:06
Part
PM.
2.
No, it's today.
All right, sorry.
Uh,
I do have it. Let's see what it is.
This one, 12:21 PM?
Today,
This one is the last one, and it's the Part 1.
Is it
Part
this,
2.
Suzanne?
Part 2?
and
Is that the one?
That's
something else she
that's
gave us
the
about
same
grandfathering.
one.
Okay. Thank you.
Okay. The original one. Is the old
Okay,
letter.
that, and that, too. Okay, okay. She's pointed out to your question about the confusion of Part 1 and Part 2.
Oh, is this it, where it says if Part 2 is zoning, then I think the reference to Part 1
Yes.
Yeah.
is just an old
Thank you,
leftover
Sarah.
piece?
Sarah, I think, or maybe
No,
this
Do
is
you
the
have it?
same thing.
Okay.
Yep.
Because I raised that question, and her interpretation is that that's just an old leftover reference that someone missed, and then I found the date that it's been amended in 2000, I think I said 17. So I don't think there's any doubt in my mind. And then whether it meets the definition of a duplex, grandfathering should not apply to this. There wasn't a duplex on the property before, so the actual idea of having a duplex there is not grandfathered. So I need to set that aside. That's something that if this goes to appeal, that's going to get argued. I'm just taking direction from our attorney. We've had, 2 continuances to get direction?
And a lot of paper and several meetings.
I can't hear you.
And a lot of paper back and forth and several meetings.
Oh, yeah.
No, when we see town attorney, it's not a meeting.
Oh, it's not a meeting. Well,
Nope.
conversations?
Yeah.
Advice?
Keep that handy. So it's like our secretary here. So I'm not comfortable going down the road of the drainage, especially stormwater drainage. What has been referenced and used and thrown around as a ordinance number, that's for site plan review. That's not for residential. I think that if we could get at it through parking, but I don't think that's something that I feel comfortable basing a decision on. I do feel comfortable basing the decision on the dimensional controls, the
Definition of a duplex.
proportions, that's two separate ones, and then that they're not grandfathered.
I think that if it's clear that the stormwater regulations are site plan and not individual lots, having to do with duplexes, then I think unfortunately it would turn out to be a civil matter, but there is case law that says that you cannot increase the runoff to your neighbor's properties. So, but the only way that that's going to be established is they need engineers to come and look at this water problem. And the drawings that we have tonight are not from an engineering firm. It's not from anyone that has any type of hydrologic engineering that we know of from what was presented to us, and we can only go by what is presented to us. There obviously is a problem there that's easy to see, and it needs to be remedied. But I'm not certain that we have jurisdiction over that.
I don't believe we do. So can I have a consensus so we can move this along that what?
Why don't we each go around and say what we think and then see if we can get to if there's a consensus?
Well, we've got a consensus on lot size,
Yeah, okay.
consensus on proportion.
Yeah.
There was a third one.
Grandfathering, but I'm not,
What one?
he's grandfathering you.
There's actually two pieces to grandfathering. Duplex isn't grandfathered, but then there's the grandfathering about the lot size. We
Correct.
haven't really tackled that one yet.
So what we have to decide was the construction interpretation of the application of the terms of zoning ordinance met by the administrative official. Let's just say that. The question is, was the construction and interpretation or the application of the terms of the zoning ordinance, and that's why I'm saying 175, 175, 175, 89, were the terms of those zoning ordinances made by the administrative official in the course of issuing the building permit? That's the core
Yeah.
question.
Right.
We've already got a consensus saying that, no, the dimensional controls weren't met. Consensus, no, similar proportions weren't met. And I don't know where we are on the grandfathered issue, other than if you look through your legal paperwork, you'll see that our advice is that it's not grandfathered.
I got one more thing.
You got what?
I have one more item.
Okay?
So a bulk of the things that I would argue are already off the table, and that is because of, obviously, what we've been advised by legal. The things that we removed in the beginning.
Right, the things that I read that,
Correct.
yeah,
A large part of my argument is based on those items.
okay.
And because it's, I believe we also have a duty to not only the process, and the process goes both ways in this situation, but we have an obligation as acting on behalf of the town of Wolfeboro. And I do take that duty seriously. I know, I'm not saying no one else doesn't. I'm just saying I see things, some of the arguments that I would make are the arguments that we've been told not to bring up. And that's fine, but That's why my position is I'm gonna side with the fact that I think the building permit was issued, it was issued properly, and I'll stand behind what the building office did.
But Luke, right now, I understand, I mean, you're wearing two hats, you know, as a.
can't hear you, Sebastian.
I said, he's wearing two hats. He's on the Board of Selectmen, and right now he's on the ZBA board. I think right now, I understand the conflict in your head with this, but I think right now you've got to wear purely the ZBA hat.
I have thought about this all weekend, and the fact is, I think that I'm wearing a hat that is a citizen of Wolfeboro, to be honest with you. Hate using that term. That is where I am coming from. I'm not worried about the town's liability and getting sued. For instance, you know, the town did work on Mr. Brown's property, and that's, you know, by and large, we don't normally do that. It does happen occasionally. That opens the town of Wolfeboro up to liability. You know, I have no vested interest here. I didn't know anyone here. I only probably talked to Mr. Beckwith 3 or 4 times in the post office over the last 20 years that I've lived here. Said hi, you know. But that's where the things that we can't talk about, I think, are important in how we got here and what we do. But I mean, there's 5 of us here, so.
I know. I just want to say, though, because we bumped up with you about this before.
We
and
have
I really
bumped, yeah.
respect you. I do. But sitting here, it is our job. We need to remember that every regulation that we uphold, every ordinance that we uphold, every law, these were voted on by the citizens of Wolfeboro. So even though these decisions may be unsavory and we may not want to make them sometimes, we are standing up for what every single person in Wolfeboro, not every single person, but what the majority of our voters said they wanted us to follow. So when you say you're there for the citizens, I just want you to remember that these laws came from them.
I understand.
It's a tough place to be.
There's nothing
When
good.
you live in a state whose motto is live free or die.
There's nothing good about having to deal with any of this decision. It's
No.
a tough decision, but there are going to be direct consequences for our actions. So.
Well, we're also sworn, when we get sworn in, to uphold the laws of the state and what you were saying, the town, as best we can. All right, so let's go. I'm going to propose some sort of a draft motion for discussion.
Before you do, can I just have one more little bit of input? I think one other thing that we can all agree on is that it is a pre-existing non-conforming lot.
Yeah.
But I think the crux of the matter that is perhaps, maybe I'm reading wrong, Luke, but I think some of the crux of the matter is the fact that there are some things that can have different interpretations because of errors in our zoning. If you look at the fact that it's stated one place in print, one thing, and another place online, but it seems to be pretty clear when you go back and look at them that it is Part 1, it appears to be the Board of Selectmen's section, if that's what you'd like to call it.
Yep,
And then the Part 2 is zoning.
zoning.
So if
You got it.
we agree to the fact that it's a non-conforming lot, but then we come to the point where we have to determine whether this Part 1 is pertinent or whether it is not pertinent to our decision, I think that'll help us come up with our final motion-making.
I'm going to try and make a motion for discussion there. In that way, it's not out there that you got to jump on it for a second. And we'll work through it till we get some language. And if you write it down, and Sarah, you write it down, and I'll write it down, and see
Since we
if
don't have a secretary.
can't, yeah. Let's see. I think we've had All right, Sabette, come on, I need you.
Sorry.
I think we've had good discussion as to reasons why we're coming forward with a motion in this manner. It isn't like the variance where we have to check off all the boxes. So a draft motion would be, let's see. Okay. To uphold the appeal and reverse the building department's decision and revoke the 7/26/23 building permit with the number. You don't have to write it down. We all know the number. It ends in 468. Lot 217013. Mr.
Wait.
Mr. Beckworth.
My pencil broke. Sorry. Okay, keep going.
As the construction and interpretation or application oh, I got it here, of the zoning ordinances were in error as follows. Number one, 17589A2, dimensional controls. Town records show lot size at,
Do you want to say town records or zoning ordinance? That's what we're talking about, is the zoning ordinance.
yeah, 179A2,
Right.
dimensional controls.
But she's going to say what the town records are for the lot size.
All right,
I don't know what she's saying. She
all
lost
right,
me.
all right, we'll take the part of the record shows. Don't scratch it.
17989A2, dimensional controls.
Controls.
Okay.
I'll take out town records. Lot size is 0.20 acre. Ordinance requires 27,780 square feet or half acre.
Half acre, okay.
Okay. 2, 175B. Oh, where'd it go? Definition duplex requires, where's B?
You want to repeat the whole thing here?
No, I don't think I'll do the whole thing. Requires
Units of similar proportions.
two dwelling units of similar proportions. The plan of 9/27/22 reflects the duplex is,
It has to be 23, Suzanne.
no, the plan of 22, the one we got in the beginning,
It's this year's plan?
No, there was a plan that we got, that he, all
Oh, okay,
right?
okay.
Definition duplex requires 2 dwelling units of similar proportions. The duplex is approximately 748 square feet. The residence living space is 2,400 square feet per tax card.
Okay, I missed something in the middle of this.
And then,
175-175B definition duplex requires 2 dwelling units of similar proportions.
Proportions.
Then you started out something about the plan 92722, and then duplex requires,
748 square feet.
okay, it doesn't require,
It said reflects.
No,
reflects.
It took, take that word requires out. The duplex is
Okay.
approximately, I'm sorry, I said requires.
Okay, is 748 square foot approximately. The residential living space is 2,400 square feet per tax card.
2,400 square feet.
What did I say?
I thought you said 25.
No, oh,
Per the tax card.
yeah, I've written down
Okay,
24.
1 and 2.
Yeah,
3, and that's where we go to your paperwork.
I don't know what paperwork you're talking about. Which one from the attorney?
The board finds that the proposed duplex change from storage, second floor storage, is not grandfathered.
Okay.
There wasn't a duplex on the property before. There was a single-family dwelling. So that actual idea of having a duplex there is not grandfathered.
Okay. All right, where are we here? No duplex.
I can't hear you. Could you use your microphone?
Sorry. While she's copying that onto this point, Audrey did mention these things kind of in a good bullet way. And she said, in case this is something you want to incorporate, she said, this parcel has an established use as a single-family dwelling. In
Yeah.
order to change the use to duplex, it needs to meet the zoning code, which it didn't. And when you change the use, it never went, to meet the zoning, there is a change of use to make it a duplex, which is what you're kind of saying.
Careful.
And that was what Laughlin was saying
Well,
too.
Yeah, but wait a minute.
Is that ahead of
This
us?
is- This is a decision. What you're saying is information that brought us to that decision, so.
Okay, but I'm saying that some of those words you could almost put into the decision. I mean, you could say something like, I mean, if that helps you with
Well,
writing the
that's gonna go
decision.
That's going to go to findings of fact,
Okay.
which attorney will do for us.
Okay, because it
And-
came from Laughlin, so that's why I was mentioning. Okay.
Well, it was said under public testimony,
Okay.
and it could be said by us, we concur, but,
Okay, so let me make sure I
Okay.
have this last one right. Board find the proposed duplex change from second floor storage is not grandfathered, no duplex on property before, just a single-family dwelling. Is that what it was? Did I miss anything?
Say that again, Sarah?
The board finds the proposed duplex change from second floor storage is not grandfathered, no duplex on property before, just a single-family dwelling. Use, I guess, is that it?
Gonna have to do.
Okay.
All right. Tavis, Tavis, I know this has been hard for you because we don't have a secretary between the recording and what we're trying to put down on paper. Do you think that we've got an understanding that somebody can type up?
I hope so.
Hopefully.
I mean, if you'd like, I can write down what I heard you say.
What do you say?
I'm not going to embellish or change. I can just read out what I heard.
Yeah, he said he can just read out what he heard.
Okay, okay.
So your point is that we need this to, soon, so we can get our 5-day decision when we ever come to one, and get our findings of fact as well, correct?
Yeah, she needs this, she needs the minutes.
She being,
Attorney.
Thank you.
Attorney needs some written record, she needs the tape, she needs what's going to be this motion, and then she'll do the findings of fact. So I'll go over it again in general, and I thank Sarah and Tavis for trying to write this down. But the crux of it is to uphold the appeal and reverse the building department decision and revoke the 7/26/23 building permit, insert number, lot 217013 for Mr. Beckworth, as the interpretation and, what was that other word I used?
Application.
The
application of zoning ordinance.
construction,
And interpretation and application of the zoning ordinance.
Interpretation
Application.
of the
cons-
application.
Right, no construction in there.
Yeah, I want the word, it's the construction, it doesn't mean household.
You said
It was
Mr.
before
Beckwith
the
as the
application. Let me read it back to you, because I
All
don't
right.
think you can read the notes you were making when you were talking. Uphold the appeal, reverse the building department decision, revoke 7/26/23 building permit number 2023000468, lot 217-013, as construction and interpretation
I know, start off with the interpretation,
as construction and interpretation or application of zoning ordinance were in error as follows.
were in error as follows.
Right.
Right,
Okay, all right.
right.
And then we had 175-89, 175, 189A2, 175, 175B, and then we did grandfathering. So, is everybody clear of what we've done? I would make, Sarah, why don't you make a motion to deny per what we've just come up with?
So I will just read this, what we've come up with so far. The motion as follows.
Okay.
Uphold-
Yeah, all right.
uphold-
And somebody second that?
Second.
All in
So,
favor, roll call vote. Luke?
Tavis has a question.
There's discussion time?
I'm sorry?
We're going to have a
it started with you making a motion. So now is Sarah making that motion that you made?
What?
You originally started to make the motion, I wrote it down, and Tavis's question is,
Who made
do
the
you want
motion?
me to make the motion because I wrote it down, was his question. That's fine.
Yeah.
It would be the complete motion with what I just read before, the number 1, the number 2, the number 3, and then Sabet seconded it for discussion. So I think we should have the discussion before we take any roll call vote.
Yes.
And Luke, I think you want to discuss something.
No.
No?
No.
Okay.
I do,
Okay,
Kate does.
yeah.
speak into the microphone loud.
Okay, all right, thanks. Well, I'm a little bit ambivalent about this whole situation. I think, I'm sort of sympathetic to some of the things that have been said about housing and affordable housing and also the ability for someone to increase their income. I think, and we have a non-conforming lot and talk about grandfathering, I think that, maybe the solution to this is an ADU, which would be okay on a non-conforming lot, but I do think that, that this does not meet the requirements for a duplex, and which is a new use and has requirements, and so I'm inclined to uphold the motion, with some ambivalence, but I think the the decision seems fairly clear.
Okay. Roll call vote. All those in favor of the motion?
You have to do it one at a time.
A roll call vote. In favor of the motion. Luke?
No.
Sabette?
Yes.
Sarah?
Yes.
Suzanne? Yes.
Yes.
4 yes, 1 no. And
One no.
thank you, Sarah. And I would say, I don't have my notes on that, but there is an appeal process. Our decision can be appealed.
A notice of decision should include something as, any party to this application, any person directly affected by it may apply to the ZBA for a rehearing within 30 days of the ZBA's vote as provided in RSA 677:2. Appeals from the ZBA's decision thereafter be made to the Superior Court under RSA 677:4, or the Housing Appeal Boards under RSA 679:6.
Thank you. So that the hearing is closed. The decision is made, and it can be appealed. Thank you all for attending.
We have to do Audrey's.
Now, pardon?
We have to do the second
Before the one.
Audrey's.
We have a second,
I got
were you two?
for COVID.
Sabette, I need your help here.
Oh, sorry.
We have a second item on the agenda, and it's Robert Kent. It's 10 minutes to 10, so I think you know where I'm going with this. I think it would be best to open the hearing and continue it to a date, time, place.
I think you need to determine if you have jurisdiction, and then if you want, open the hearing.
Can I use the restroom for a second? Can we take a break for a
Take a
second?
break.
Oh, take a break?
Yeah, like a 10-minute break so people
10-minute
can go
break.
potty.
Yeah.
But don't you want to continue this at 10 o'clock? We're going to start it?
We have to determine if we have jurisdiction. Didn't you?
5-minute bathroom break, and we can go longer if needed.
Okay.
Audrey's been waiting a long time.
I think when their eyeballs are floating anyway.
Let's get it done. I gotta go.
TV, hello.
Yep, he's back on.
Thank you. So, this is an appeal by Mr. Roger Kent, 16 Libby Street, tax map 21713, case 08 AAD 23. Before I open the hearing, did the representative for Mr. Kent leave? Okay.
But remember, people don't speak until you open the hearing. Nobody speaks but you until you open the hearing. You as a board.
I'm thinking of something else.
Okay. Those are the things that should be out loud.
So somebody's here.
Oh, okay, yeah, well, it's not the presenter, but, we first have to decide if we have jurisdiction. I'm just trying to decide if we should announce that there was a site visit and report on that, or...
Jurisdiction first.
Yeah. Okay, the board held a site visit for Mr. Roger Kent of 16 Libby Street this
No,
evening.
you have to do jurisdiction first.
Oh, I was just going to have you report the site visit?
No,
He said yes.
no, he didn't.
Oh, he didn't?
No.
Jurisdiction first.
Okay. The board needs to decide if it has jurisdiction over the case for Roger Kent. I would think that basically we had jurisdiction over a similar issue. We have jurisdiction over that. But I will read to you 674-33, powers of zoning board of adjustments. The zoning board of adjustments shall have the power to hear and decide appeals if it is alleged there is an error in any order, requirement, decision, or determination made by an administrative official in the enforcement of any zoning ordinance adopted under 674-16 and authorize upon its appeal in specific case, and it goes on. So I would move that the board has jurisdiction over this case under 674-33. Second? Anybody? Second? Discussion?
Are you going to second it?
I was just going to ask, when did the discussion about the timeliness of the appeal come in? Does that come in under jurisdiction or no?
No, that would come in at the hearing.
Okay.
How does the board feel about taking jurisdiction on this case for Mr. Kent?
I'm sorry to ask you to do this, but would you read that one more time?
Read this again? 674-33. You got your trusty little computer there. Powers of the Zoning Board of Appeals, Zoning Board of Adjustments. 674-33, 1 and 2. And it's a whole long thing, but I'll read the...
No, I've got it. I got it now. All right.
Okay.
So I second.
What?
Second.
I second.
Second, okay. All those in favor of taking jurisdiction? Roll call.
Yes.
Yes.
Sabat?
Yes.
Yes.
Yes, okay. So now, before I open the hearing, I would ask the applicant's representative, we don't have a full board of 5. We have a full board of 4. Would you like to continue with a board of 4? The applicant's representative said no.
Okay.
So we will then continue this hearing until I'm going to get a date. The time and the place will be the town hall. The time will be...
Well, Ordinarily, you would go to the 16th, but there's a budget committee meeting on the 16th, so you cannot be in here at 7 o'clock. If you want to do it on the 16th, we can look for a different location. But I cannot confirm this room on the 16th.
Well, it doesn't have to be this room, I guess, but, yeah, it does because of the,
Let me rephrase. I can only speak about this room at the moment. I do not know if the library has something open. Obviously, the whole group cannot fit in the conference room, either of them.
well, we have 90 days to make a decision, and
Well, if you continue it, you need to continue to a time, date specific.
Okay.
Can we continue to the 23rd of October?
That's better for me.
it doesn't have to be a Monday.
It does not. It could be tomorrow. Not tomorrow, there's planning board. It could be Wednesday.
The other selectmen.
Could be, you see what we're going
Thank
down.
you.
So you need to think of
Thank
a
you,
date,
Luke.
and I will try and run
I hate to be the
down
only
the
one
rabbit
that
hole.
keeps reminding people we have other meetings other nights.
Whatever Tavis can come up with is we'll have to just be here. But I need to know tonight what you think would work. Any night of the week except,
You know what'll work, Suzanne? The first Monday of the month in November, because that's our day here anyway, so we're not going to get bumped out of that date.
that's another month away. Okay, let's do it, our regular meeting night.
That way we have a
I
definite
mean,
date.
for the benefit of the board, regardless of the outcome, you've already taken action that would likely be, not saying you're going to come to the same conclusion, but it would be somewhat surprising to hear a similar appeal on exactly the same subject matter and come to a different conclusion, although that would be fun. But odds are you've already made a motion to revoke the permit. So I don't see any harm necessarily. I mean, if you wanted to do it in this room, we could look at the 9th, we could look at the 11th, we could look at the 19th, the 25th.
Works for you, Sarah.
I don't know, I can't find my calendar thing on my phone. I have a bunch of other meetings already scheduled.
The 19th works.
19th, fine.
Does
Yeah.
work for Audrey?
What are you trying to say? I can't hear
She said
you.
November was fine.
November, whatever the first Monday in
That would be November 6th.
6th is fine with the applicant.
You know, in some ways, is it good to wait till November 2 so that all of the conversation about this case is separate, kind of separate in our head
Well,
about
we'll
the conversation
figure
at that?
We'll figure
But I
that
mean,
out.
I'm just saying the distance could
We aren't
work.
even there yet. Let's just get a date.
Okay.
11/6 at 7 PM, right here.
What have you got?
November 6th.
November 6th, 11 PM, it's a regular Monday ZBA meeting night.
Okay. So I've named the time, date,
So
and place.
that was a motion by Suzanne Ryan to continue to November 6th at 7 o'clock in this room.
Second. You don't vote in favor, I'm going to smack you both.
Yes. Where's discussion? Yes.
What? Are you voting in favor of November 6th?
Oh, yes.
Thank you, ma'am. Yes?
I can't hear you.
Tuesday, the 7th is election day, and that will be an issue because this will all be
Oh,
converted.
yeah, it is, that is true.
Wait,
Well, that's fun because there's a planning board meeting on that night too, so
yeah, but there aren't, wait a second. There are no elections.
there are no
November.
elections.
There are no November elections.
It's
So-
not, this calendar is marked specifically for
Okay.
this group at that
No,
time.
If it was.
So we are good.
We are good?
Yeah.
Okay. All right. He voted yes, she voted yes, I voted yes.
I'm voting yes.
Motion to adjourn?
Yes,
Yes.
second.
Second?
Yes, Sarah.
Yes.
You are on for the 6th?
Yeah.